the students for having me here today. It's a wonderful afternoon. Just after we celebrate the 78th Independence Day today, we should all be proud and reflect on what the founding fathers of our nation and constitution expected from all of us. Moreover, today we should also consider what independence and creation of a democratic state means for the marginalized sections of our society, including the scheduled caste, scheduled tribe, OBCs. Uh, including the am I audible? Yeah. So including the scheduled tribe, scheduled caste, OBC, and women, who form the majority population of this country. Dr. Babasaheb Ambedkar's broadcast speech from the Bombay station of All India Radio, he said that the principle of self-government expresses the desire of the people to rule themselves rather than to be ruled by rulers, whether the rulers be absolute monarchs, dictators, or privileged classes. It is called democracy. Dr. Ambedkar argued that democracy should ensure representation of opinions and representation of persons. In the book Annihilation of Castes, Dr. Ambedkar said that every congressman who repeats the dogma of Mill, that one country is not fit to rule another, must admit that one class is not fit to rule another class. Hence, to ensure that we move into an egalitarian social order, Dr. Ambedkar didn't only recognize former equality, but also real equality, which means giving reservation, adequacy of representation to each and every class in the society. According to a 2023 report of the Parliamentary Committee on Scheduled Caste and Scheduled Tribe, in which they analyzed data, they found that out of scheduled caste reservation is around 15%, as you all know, and scheduled tribe reservation is around 7.5%, except group C including safai karamcharis and group C excluding safai karamchari. Except that bracket, in each and every bracket you will find that the representation of scheduled caste is below the mandated 15%. Similar is in board of directors in all ministries, PSUs, banks, etc. Even if you see the media, then media also you will find that in 88% of top leadership positions, these are occupied by privileged high caste individuals, and none of the mainstream media has people belonging to SC/ST categories in the leadership roles. Friends, if you consider the judiciary, then you will find that in judiciary, scheduled caste have only 3% representation in High Court, scheduled tribe only 1%, and OBC, which constitute 50%, they have only 10% reservation in High Court, 10% representation in High Court. There is no reservation there. So now I go to the judgment which Supreme Court has passed just on 1st August, in which Justice Pankaj Mittal says, I am of the firm view that in primitive India there was no existence of any kind of caste system. Rather, there was categorization of people according to their profession, talent, qualities, and nature. So in para 84 of the judgment of Justice Pankaj Mittal, who was a part of the bench, he says that our country has moved into a casteless society except for the deeming provision under the constitution for limited purposes of affording reservation to the depressed classes of individuals. So he says that our country has moved into a casteless society except for giving reservation. Except reservation, everywhere you will find that we are in a casteless society. In which direction are we moving, friends? When direct discrimination today is on basis of caste, how can the solution be arrived without looking at caste? Will that be a correct solution? I leave it to all of you. In a written reply before the Lok Sabha, Minister of State in Prime Minister's office, Mr. Jitendra Singh, he shared data on how much vacancies are there in different government organizations, specially reserved for SC/ST, which are not filled yet. And we found out that there are around 78,923 vacant posts in railways, housing, urban affairs, defense, atomic energy, financial services. So around 79,000 vacancies in these ministries. There will be lakhs of vacancies if you consider on a whole. Dharmendra Pradhan, the education minister, said that 42% of teaching posts of SC/ST OBCs in 45 central universities, they are lying vacant. If you see IIMs or the top 20 premier business schools, you will find that 62% scheduled caste seats are vacant, 79% scheduled tribe seats are vacant, and 63% OBC seats are vacant. This is the place where reservation is implemented, but still they are not filling up seats. What about those institutions in which reservation is not at all implemented? I will just give a very basic example. If you see Lok Sabha, then in Lok Sabha, there is reservation for scheduled caste, scheduled tribe. There are around, according to the Delimitation Commission, which was there in 2008, they recommended 131 MPs for SC/ST in Lok Sabha. Now you compare it with Rajya Sabha. How much MPs does of scheduled caste, scheduled tribe, OBC does Rajya Sabha have? You will find that they are a very minuscule minority, not even close to the number which we have in Lok Sabha. All this, looking at this formula, you will get to know if you want to ensure adequacy of representation, if you want to ensure democracy, which Dr. Babasaheb Ambedkar said is an aspect of representation is an aspect of democracy. If you want to ensure democracy and if you want to ensure representation, then the only solution is reservation. So, bottom line, what is happening in today's society? Uh, First of all, what are these guys doing? They are not filling up SC, ST, OBC vacancies where reservation is there, and they are not following reservation norms where they are constitutionally bound to do. As a result of this, I was talking to one UGC secretary. He was part of some committee, and he told me that there is one organization since 1970 which was established in 1970. Former UGC secretary told me this, and since 1970 they have not followed reservation norms. So you can see what is the phase and what are the phase of things we are seeing. And as a result of this, what is happening? See, our people, they don't have money or connections by which they can land into business. They face discrimination in private jobs. All of you are students, you know very well that in private jobs, most of it is based on recommendations. A lot of, if not all, then a major population or major part of private jobs is based upon recommendations. When you don't have people working in private sector, from where will you get these recommendations? The only solace which people of reserved categories, SC, ST people have is that they have government jobs. And now, as we stated, as data is showing, they're not filling up vacancies of government servants in these government organizations, and they are not implementing reservation in places where it should be implemented. So, therefore, where will that common marginalized person go? He has no place. And upon all of that, what are they propagating? They are propagating that there is a particular group in the scheduled caste or in the scheduled tribe which has taken up all your reservation, because of which you are not getting your adequate share. This is what they are propagating, leaving aside, shifting the focus from the number of vacancies, from the number of places where reservation after 75 years is not being implemented. They are shifting your focus and telling you that you are not getting your share, not because of our fault or not because of some other fault, but because there is a particular category inside the scheduled caste, inside the scheduled tribe, or inside even the backward class, because of which they are eating up your share and you are not getting what you deserve. When I was a child, my mother told me a story. It was Old Man and His Son, or it is also called a bundle of sticks. In that story, you must have heard about that story. In that story, what happens is a father was getting ill. So he calls his children and he gives them a bundle of sticks. And his children were very quarrelsome. They used to quarrel with each other. So their father called all of his children and he gave them a bundle of sticks. And he asked his children, "Do you break this bundle of sticks?" Now, when the children were trying to break that bundle of sticks, they were unable to do so because the bundle of sticks were bound together. Now, the father, he removed that the binding factor, and one by one he gave them each single stick, and every person, every son, he was able to break that stick. So, moral of the lesson of this story, which is part of the Aesop's fable, was that there is strength in unity, and he teaches them that through each in some way he teaches them, though each can overcome alone, they are invincible combined, friends. That is the lesson. And Dr. Ambedkar, in his last speech to the Constituent Assembly, quoted Abraham Lincoln and said, "For as has been wisely said by Abraham Lincoln, a house divided against itself cannot stand very long." That is why Dr. Ambedkar said that therefore sooner room is made for realization of aspirations of the marginalized, the better for the few, the better for the country, the better for the maintenance of independence, and better for the continuance of its democratic structure. How can this be done? Dr. Ambedkar said this can only be done by establishment of equality and fraternity, which means brotherhood in all facets of life. That is why he said he laid so much stress on equality and fraternity. Dr. Ambedkar he wrote a book, Annihilation of Caste. You all are aware about that, in which he said one thing. He said many things. Among that, one very major thing he said was that caste is not based upon division of labor. Caste is based upon division of laborer and laborers. And if you want to stop caste, if you want to dismantle, annihilate caste. He advocated for intercaste marriage and many other solutions he gave. But what are the anti-reservationist people telling us today? They want to end reservation, but they do not want to end the caste system. They are not at least talking about how to end the caste system. Their entire focus is on how to end this protection of reservation. And divisive forces, friends, are creating these hatred in minds of our fellow beings, and even who are our fellow beings, they are creating hatred in their minds. They are telling them that your share is being taken by some particular class of people, but they are not but they are not letting you focus on the real issue. So I hope that you will understand, according to your interpretation, what is the real issue. This was the social aspect of which I wanted to discuss. Now I am moving to the legal aspect. I was also part of I also appeared in the Supreme Court in this matter, State of Punjab versus Devinder Singh, in which the Supreme Court decided for subclassification, or as you have discussed it, dividing the scheduled caste and scheduled tribe, and also they applied creamy layer. So first of all, to understand, now I'm moving to the legal aspect. Legal aspect, if you see, then Article 341 of the Constitution, it talks about scheduled caste. Who is a scheduled caste? So scheduled caste, 341 clause 1 says that president may, with respect to any state or union territory where it is a state, after consultation with the governor thereof, specify caste which will deem to be a scheduled caste. So the president has to make a list under Article 341 as to who is a scheduled caste, and under Article 342 as to who is a scheduled tribe. Clause 2 says, now this is very important to understand the legal principle, whether there can be subcategorization or not. This has nothing to do with politics, but with constitutional interpretation. Second clause says Parliament may by law include or exclude. Parliament may by law, you should note this, include or exclude from the list of scheduled caste specified in that notification. So once a list is made by the president under Article 341 for the scheduled caste and 342 for the scheduled tribe, if you want to include or exclude, in other words, if you want to tinker with that list, that can only be done by the parliament. That is what Article 341 and 2 states. That is the plain meaning. It does not require any constitutional interpretation to understand the basic words of our constitution. Therefore, the first judgment which dealt with the interpretation of Article 341 of the Constitution was E.V. Chennaiya, like sir who introduced me also said. E.V. Chennaiya case, what happened was that in the state of Andhra Pradesh, the Andhra Pradesh subdivided different caste in the scheduled caste list, and they divided scheduled caste into four major groups. Yes, in four major groups, and they gave different percentage of reservation to these four groups. This matter reached the Supreme Court, and this matter reached five judges bench of the Honorable Supreme Court. Five judges bench of the Honorable Supreme Court said you cannot subdivide, subclassify the scheduled caste because they form one homogeneous group, and if you add, subtract, if you group or classify, what are you doing? You are basically tinkering with the list. Who is tinkering with the list? State government is basically tinkering with the list. They are interfering with the list. And if you remember, I told you Article 341 Clause 2 held that tinkering with the list is only possible by the parliament through a law, not by any state government. Therefore, if you consider the legal aspect, then constitution is clear. Tinkering with the list of scheduled caste, scheduled tribe can only be done by the parliament by law. Therefore, it cannot be done by an executive action. It cannot be done by a state government exercising their power. It can only be done by parliament. Now, this why did the Supreme Court come to this conclusion in E.V. Chennaiya? I will just deal with that. Supreme Court came to this conclusion because Supreme Court said, relying on Dr. Babasaheb Ambedkar's quote on this, and Supreme Court said that there is no express provision in the Constitution which deals with subclassification. Therefore, when there is no express provision, how can you subclassify? Secondly, they quoted a speech of Dr. Babasaheb Ambedkar which he made in the Constituent Assembly. The Article 341 which we have today, that was Article 300A in the draft Constitution. And Dr. Ambedkar said, while discussing Article 300A, I will just quote it for you. Thereafter, after he says, it's a long quote, I will just read a part. After the president has made a list enumerating the scheduled caste and scheduled tribe, And I quote what he says: thereafter, if any elimination was to be made from the list so notified, or any addition was to be made, that must be made by Parliament and not by President. The object is to eliminate any kind of political factor having play in the matter of disturbance. Kindly note this word disturbance in the schedule so published by the President. Therefore, Dr. Ambedkar said that once a list is made by the President, disturbance, any kind of disturbance, not only addition, subtraction, any kind of disturbance which includes subclassification, exclusion, addition, can only be made by the parliament by way of law. Because of this speech which Dr. Ambedkar made in the Constituent Assembly, Supreme Court interpreted that it is not possible in E.V. Chennaiya that it is not possible for the state governments to subclassify or to categorize different individuals or different castes of scheduled caste into different categories A, B, C, or D. As discussed, this indicates, furthermore, there was an amendment which was tried to be made by Shri Kuldhar Chalia. He said that this power of subclassification should be given to the state governments, as we are holding this discussion today. And the Constituent Assembly rejected this amendment. Therefore, Constituent Assembly was very clear when they made Article 341 of the Constitution that that once scheduled caste, scheduled tribe list is made, it can only be tinkered with, it can only be interfered with by the parliament if they make a law, not by any other means. So, as a result of this, Chennaiya said that it is impermissible to tinker, and on the creamy layer principle, Chennaiya said that if you are applying creamy layer, for example, if you are applying creamy layer to scheduled caste or scheduled tribe, then what are you doing? Indirectly, what are you doing? You are excluding a category of people who belong to scheduled caste, those who have earned some kind of money, those who have crossed a particular threshold of their income. You are excluding them. Since Dr. Ambedkar and the Constituent Assembly made it clear that you cannot tinker with the list of scheduled caste, scheduled tribe, therefore it is constitutionally impermissible to apply creamy layer formula on scheduled caste, scheduled tribe. This is the constitutional interpretation which Supreme Court gave in the E.V. Chennaiya case, which you must note is a 5-judge Constitution bench judgment. Indira Sahni, in paragraph number 792 of the judgment, they said they applied creamy layer concept. Indira Sahni is a 9-judge bench judgment of the Supreme Court. In Supreme Court, how it works, or in our judiciary, how it works, is that benches which have a larger composition, their judgments are binding on benches who have a lower composition. Therefore, 9-judge bench of Indira Sahni is binding on 7-judge bench of State of Punjab versus Devinder Singh, which we are discussing today, and E.V. Chennaiya, which I am talking about right now. Therefore, in 792 Indira Sahni, which is a 9-judges bench decision, the majority of that court, they said that you apply creamy layer concept to the OBCs, but they said discussion is confined to other backward classes only and has no relevance in the case of scheduled caste and scheduled tribe. They said that creamy layer concept has no relevance for the scheduled caste and scheduled tribe. You can apply it. They approved it for the OBCs. Whether that is correct or not, according to me, it is not. But still, that is a different debate altogether. Then they said that in Chennaiya that since Indira Sahni has said that you cannot apply creamy layer to SC/ST, therefore in Chennaiya also, which is 5 judges, it is binding principle, and they said that we will not apply creamy layer to the SC/ST. Now coming to the judgment of State of Punjab versus Devinder Singh, delivered on 1st of August 2024. First, this judgment was basically dealing with whether the judgment in E.V. Chennaiya is correctly decided or not, meaning thereby whether you can subclassify scheduled caste, scheduled tribe, or you cannot subclassify them. That was the issue in the State of Punjab versus Devinder Singh. How did we reach here? In Punjab, they gave the State of Punjab versus Devinder Singh. It basically deals with issues from 3 states: Punjab, Haryana, and Tamil Nadu. In Punjab, out of the scheduled caste reservation, they reserved 50% seats on preferential basis for Balmiki and the Mazbi Sikhs. In Haryana, they made 2 categories, category A and category B. In category B, they put 6 castes. In category A, they put 36 castes, and they gave different reservation for both these categories. Similarly, in Tamil Nadu, they give some preferential reservation to Arundhatiyars who are also scheduled caste in Tamil Nadu. And as I just discussed, E.V. Chennaiya was holding the field at that time. Therefore, this subclassification division was illegal in terms of E.V. Chennaiya. Therefore, the Punjab and Haryana High Court, when these matter reached there, it declared this subclassification illegal, and hence the matter reached Supreme Court. Supreme Court has referred the matter from 3 judges to 5 judges, from 5 judges to 7 judges. And one thing to note in this, I will just shift back to the social aspect because I was discussing Punjab. In Punjab, you will note, I will just come back to the legal aspect in a while, but after discussing the situation in Punjab. In Punjab, if you consider the Punjab Scheduled Caste and Backward Classes Reservation in Services Act 2006, it gives in Group A and Group B 14% reservation for Scheduled Caste, and in Group C and Group D they give 20% reservation in Scheduled Caste for Scheduled Caste in Group C and D. So C and D 20%, A and B 14%. Now, if you see 2011 census of Punjab, you will find that the percentage of Scheduled Caste alone in Punjab is 31.94%. Therefore, by this subcategorization, what has happened, according as a result of division, people are not aware of this of their rights of reservation, and they continue to compete with each other and fail to see the larger picture. Because if population of Scheduled Caste in Punjab is around 32%, then reservation should also have been 32%. But they give reservation of 20% and 14%, and people, they are fighting amongst themselves and they forget what is the larger question. That is the issue which we are discussing today, and I hope you are understanding what I am trying to say. Friends, then all these matters from Punjab, Haryana, from Tamil Nadu, they were tagged, they were heard together, and the judgment which came as a result of all these 3 matters, along with matters of many other states, we got this State of Punjab versus Devinder Singh judgment. The dissenting judgment said that if you want to refer any matter from 3 judges to 5 judges, or from 5 judges to 7 judges, then you have to give adequate reasons. Because I told you that at that point of time, E.V. Chennaiya, which was a 5-judge bench decision, that was covering the field. Therefore, legally, it was at that time, it was not permissible for the government to make such kind of classification among the scheduled caste. As a matter of procedure, in the Supreme Court, whenever a matter is referred to larger bench, for example, if a 3-judge bench, when first time a case is listed in Supreme Court, it is in 2 or 3 judge bench composition. So in this case, what happened was that when this case was first listed in 3 judge bench composition, the honorable judges then, they did not assign reasons why the judgment in E.V. Chennaiya is wrong, and simply they referred the matter to 5 judges. This Justice Bela Trivedi held that this is wrong on part of the Supreme Court, and that is why she held that this reference to Constitution bench itself is impermissible and illegal. That is why she wrote a separate dissenting judgment. Yes. Now that was one aspect of the dissenting judgment. I will come back to that. What did the majority say? Because if you remember Chennaiya said you cannot tinker with the list of SCST. How did they deal with this tinkering issue? Majority led by Justice Chandrachud and Justice Manoj Mishra, they held that subclassification within the scheduled caste for the purpose of affirmative action, including reservation, does not include or exclude any caste group from the list. They essentially held that when you are subcategorizing, classifying or dividing, then you are not taking out or adding any particular caste. You are just defining the proportion in terms of percentage. Therefore, that is permissible. But if you remember what we were discussing and what I was emphasizing on, Article 341 read with Dr. Babasaheb Ambedkar's speech on Article 300A in the Constituent Assembly. It makes it very clear that you cannot tinker with the list. It is not about adding, subtracting or modify. It is you cannot modify the list. You cannot tinker or interfere with the list. If you have to interfere, then you will have to bring a law on that subject. That is what the Constitution says. But the majority judgment by Justice Chandrachud, it said that since you are not adding or deleting any caste, therefore it is permissible. And they said that they also put two caveats that if you want to subcategorize, then states can subclassify based upon inadequate representation of certain castes. However, states must establish the inadequacy of representation of caste group because of backwardness. Therefore, they limited reservation, subclassification of reservation on two things: inadequacy of representation and backwardness. Kindly note this. I will come back to the effect of these two words. These two words, they are looking very simple, but if you read it in perspective, you will find that this is a very big question mark, or it's a very big question mark which they have raised upon reservation. Justice Gavai said, and bottom line, what his argument was, I will tell you. Justice Gavai said that the basic error appears has to be committed in EV Chennaiya is that it appears on the understanding that Article 341 has to do with reservation of seats. But as I just told you, uh, in EV Chennaiya, I did not read anywhere that 341 is for reservation of seats. 341 is only for identification, and that is specifically and positively dealt with in EV Chennaiya. But Justice Gavai in his decision says that he says that the basic in para 250 basic error that appears to be committed in EV Chennaiya is that it proceeds on the undertaking that 341 has to do with reservation of seats. However, Chennaiya does not say that 341 deals with reservation of seats, but Chennaiya, relying on Dr. Ambedkar, says that only the parliament can tinker with the scheduled caste list and no one else. So, again, he reiterates it in paragraph 251. Now, the second argument which Justice Gavai makes is that you can do subclassification, but you cannot give 100% reservation to any particular caste, because giving 100% reservation to any particular caste would mean you are excluding others. Therefore, you cannot do that. But I think, according to me, this argument might be self-contradictory, because even if you are not reserving 100% for a particular caste, but you are reserving, for example, on preferential basis 40% if you are reserving for a particular caste, then what you are doing for the other castes, you are tinkering with the list to the extent of 40%. So that is also tinkering. So if you are if you are understanding what I'm trying to say, then even if you are not completely excluding a caste, even if you are partially excluding a caste, that also is tinkering, which was prohibited in terms of Article 341 read with Dr. Ambedkar's speech. Now, the data requirement which was laid by Justice Chandrachud, adequacy of representation and backwardness, is also followed in similar words, not the same words, by Justice Gavai. Now, coming to the practical problem of these two words. These two words look very simple: adequacy of representation and backwardness. I will just take you in flashback to 1992 when Indira Sahni's decision came. When Indira Sahni's decision came, 9 judges bench of the Honorable Supreme Court held that under Article 16 Clause 4, reservation in promotion is not at all permissible. So when they said reservation and promotion is not permissible, they gave 5-year bracket period that till 5 years you give reservation promotion. After that, since the constitution in Article 16.4 does not explicitly say this, therefore reservation and promotion, in 92 they said it is not permissible. Then in 1995, there was an amendment in the constitution, 77th constitutional amendment, in which they specifically said that you can do reservation in promotion. They added Article 16 Clause 4A, if you read in the constitution. Specifically, they said that you can do reservation in promotion. 1996, Honorable Supreme Court starts applying catch-up principle. Catch-up principle means that if you belong to scheduled caste, scheduled tribe category, and if you are promoted on basis of reservation, then for example, if you are you go on A, from A you go to B post. B is the higher post. Now you go to B post, which is a higher post on basis of reservation. Now when the general category employee will come on the B post, he will be senior to you because he was senior to you in the feeder grade, which was the A post. This was the catch-up principle. So they essentially said, they turned the meaning of promotion. They said that you will get promotion, but you will not get consequential seniority. Therefore, another amendment, this was done in Virpal Singh Chauhan and Ajit Singh 1996-1995 judgment by the Supreme Court. Another amendment was introduced in the Constitution, which was the 85th Amendment Act 2001. So the first amendment, Indira Sahni declared reservation promotion illegal 92, 16 4A, 77th Amendment came in 95. Now, the second amendment clarifying promotion came in 2000. After Virpal Singh Chauhan, the 85th amendment, then they came in 2001. So we are in 2001 now. Now, the constitutional validity of all these amendments, they were tested in the case of M. Nagaraj versus Union of India. M. Nagaraj versus Union of India, in specific terms, said, okay, you give reservation and promotion subject to three things: inadequacy of representation, backwardness, and efficiency. If there should be no detriment on efficiency, there should be inadequacy of representation of SC/STs, and there should be, you should show by quantifiable data that scheduled caste is backward. We've fought that battle. M. Nagaraj has been neutralized to a larger extent, but even today, you all belong to that community, and you all know how many people in our community they are getting reservation in promotion. Because of these factors, in each and every cadre where reservation promotion is implemented, that is challenged in courts. Even today, batch of matters of reservation in promotion, state of Jarnail Singh versus Lakshmi Narayan Gupta, of these are reservation and promotion batch of cases. These are still pending in Supreme Court today. That means even after 30 years of 77th Amendment, till today we are fighting cases of reservation and promotion. When reservation and promotion is not implemented in many states, most of the states, wherever in some cadres it is implemented, it is challenged in courts. People have to fight from High Court, from Supreme Court, then again to High Court. So this loop is going on, and people are stuck in the cycle of stuck in the cycle of litigation. And court held that for reservation and promotion to be valid, the state has to meet the compelling requirements. But friends, now even for direct, so these requirements were there for reservation and promotion. Now these requirements they have included by way of subcategorization in direct recruitment, because subclassification is also applicable on direct recruitment. So I believe that such kind of conditions they are dangerous for the implementation of reservation. And just I'm coming to back to the judgment which we were talking about, which was State of Punjab versus Devinder Singh. I'm just taking you back. I discussed Chief Justice Chandrachud's decision, then I came to Justice Gawai's decision. Now, Justice Pankaj Mittal. Justice Pankaj Mittal agrees with Justice Gawai and Justice Chandrachud, and he says that reservation, the family which has obtained the benefit once, should not be allowed to take the advantage of reservation in the next generation. Reservation to such families has to be confined to one generation only. So therefore, he takes it a step further. More than creamily, he says, no, I agree with Justice Gawai, I agree with Justice Chandrachud, but it should only be for uh, one generation. Now I am coming to the dissenting judgment, which is an excellent judgment written by Justice Bela Trivedi. She held that creamy layer cannot be applied to scheduled caste, scheduled tribe, since the same has been rejected in Indira Sani, which I have already discussed. And she says a bare reading of Article 341 says that the SC scheduled caste and 342 scheduled tribe list cannot be varied except by Parliament through a law. Now, very important aspect she says, which we were discussing a few moments later. I will just try to read. Reference given to any quota reserved for a particular caste or race or tribe out of the quota reserved of the entire class of scheduled caste for the government job by the state would certainly deprive the other member of scheduled caste from having the benefit of reservation to the extent of the quota. She comes back to the same thing which we were discussing. Even if you are limiting quota subclassification to a particular percentage, you are not excluding per se. Still, you are excluding to a limited proportion, and that proportion constitutes tinkering, which is illegal in terms of 341. That is what Justice Bela Trivedi held. So, bottom line, why this classification is wrong? Firstly, because scheduled caste is a homogeneous group. Homogeneous group means that there is one thread which binds each and every scheduled caste person. That is, the scheduled caste people, they were untouchables in the past. Therefore, this is a homogeneous class. Second, why subclassification is wrong according to me is that Indira Sani said, which is a 9 judges bench. This is a very technical thing, but you should understand. a 9 judges bench has said that you cannot apply the test of backwardness to scheduled caste, which means that scheduled caste, scheduled tribe, they are presumed backward. You cannot say that a particular scheduled caste is more backward, a particular scheduled caste, scheduled tribe is less backward. You cannot apply the test of scheduled backwardness to scheduled caste and scheduled tribe. Therefore, it is impermissible to classify them on basis of backwardness, and they are classifying on basis of backwardness because the data which they are approving, which they want to justify, is based upon backwardness. But Indira Sani says that you cannot classify, you cannot say that particular scheduled caste, you cannot apply the test of backwardness on scheduled caste. This is second is the creamy layer principle. According to me, that is wrong. I will just quote a judgment of the Supreme Court on to illustrate why creamy layer principle is wrong. This is the Supreme Court judgment in state of Karnataka versus Appa Balu Ingale. In this judgment, the Honorable Judge in para 17, he notes that the statue of Swami Sarvapurnanda at Varanasi, when unveiled by no less than the Deputy Prime Minister of Free India in February 1978, Shri Babuji Jagjeevan Ram, it was believed to have been defiled and purified ceremoniously with water brought from Ganges. Similarly, at a dinner hosted at the Speaker of Rajasthan Legislative Assembly in honor of Chief Minister of Jagannath Pahadia, wife of Speaker trembled to serve food to Chief Minister, thinking it to be polluted. Third, this is the Supreme Court judgment which I am quoting. This is not my words. A Dalit judge in North Indian High Court could not secure a house and had to get posted to another place where he had his abode. I quote what the Supreme Court further says. Thus, even persons who improve their social status, economic positions, or holder of constitutional offices, there is no bigger position than a deputy prime minister, judge of a high court, or a chief minister. Or these are very important constitutional positions. Supreme Court says, thus, even persons who improve their social status, economic positions, or holder of constitutional offices are no exceptions to the wrath and plague of untouchability and are self-evident truths. So Dr. Ambedkar is right when he wrote that untouchables are born and die as untouchables, and the scorn and scrop is carried from birth to their graveyard. Secondly, even if some people earn money, for example, if some people from scheduled caste or some people from scheduled tribe, they have earned money, they are living good lives. So what effect does it have on the community as a whole? Let us understand that. I was reading an article, it is by Professor Owen M. Fiss. The name of the article is Groups and the Equal Protection Clause. He is a professor in Yale University, and this article is largely relied upon by Supreme Courts, not in India, but throughout the globe. He analyzes what is the effect of money on the group to which the person belongs. He gives an example of blacks because he's teaching in Yale. So he says that, for example, if there is some black who is rich, so preference of rich black may be justified in terms of improving the position of the group. Even if blacks are preferred happen to be rich, a benefit abounds to the group as a whole. Members of that group have obtained these positions of power, prestige, and influence that they otherwise might not have to that extent. The status of the group is improved. He says that even if some people of a group they make money, then although they are individually making money, but still the status of the entire group is increased. And however, when you give preference or affirmative action or reservation to a poor person, what happens if a poor person becomes rich? The class of his class changes. So poverty is not a permanent class. It is a temporary class. But if person is, for example, O&M says he's black, then if he is rich or if he is poor or if he is middle class, he remains to be black. And if he remains to be black, he will remain to get all the disqualifications, all the discrimination. Therefore, black is black whether rich or poor. And if some members of the black community get rich, that increases the status of the whole group, which is the idea of reservation. That is group equality, not individual equality. Conclusion, I just conclude by giving 5 basic points. We should move towards inclusion and annihilation of caste rather than increasing the diversive prevalence through dividing the subcastes of scheduled caste, scheduled tribe, OBC, which is otherwise a homogeneous group. Moreover, if division or subcategorization of SC/ST was so good, then why didn't Dr. Ambedkar, he was so foresighted, why didn't he himself, he had all the power at that point of time, why did that proposal get rejected? Why didn't he himself incorporate this in our constitution? Secondly, Article 342, 341, under the scheme of the Constitution, sub-classification creamy layer on SC, ST, and even on, according to me, even on OBC, that is impermissible. Thirdly, lastly, I just wanted to conclude uh, with a small thought, which is that there are many thoughts going on in the society which say that it is up to the government to accept creamy layer or not. Let me tell you, judgment of Supreme Court is binding on the government. Government cannot simply say that okay, we are not following the judgment of the Supreme Court. In every country, each and every country, and it should not be like that. Each and every country in the world which is based on rule of law, there is independence of judiciary. Decisions of judiciary, they are binding on the government, except only if the government comes up with a constitutional amendment changing the basis of the entire decision. Until and unless the basis of that decision is changed, this judgment will be effective in full force. The basis of the government basis of judgments has been changed many times, like I just gave you example in Indira Sani with respect to reservation and promotion and consequential seniority. So until and unless that is done, the this judgment, State of Punjab versus Devinder Singh, remains with full force, and it cannot be restricted just by the government saying that we will not implement. They are bound to implement, except if they come up with a constitutional amendment. Thank you so much, everyone, for the patient hearing, and it is indeed an honor for me to be with you all. Jai Bhim, Jai Bharat, Jai Samvidan.